Welcome to the video lecture series of Project Development and Resource Management, course code MC301, contact hour 4, credit 4. This is lecture 8. Myself, Dr. Shunipa Roy, head of the department, Electronics and Communication Engineering, Guru Nanak Institute of Technology, Kolkata. So this is module 2. Module 2 actually consists of agreement of trade-related aspects of intellectual property rights. What is intellectual property? Importance of IPR patent, types of patents, patentable inventions, who can apply, rights and duties of patentee, infringement and remedies. So the lesson plan for this particular lecture is what is intellectual property, importance of IPR, patent, types of patent and patentable invention. So let us start with what is intellectual property. Actually, it is a term referring to a number of distinct types of creations of the mind for which property rights are recognized. And intellectual property right, what is that? Actually, this is a right that is had by a person or by a company to have exclusive rights to use its own plans, ideas or other intangible assets without the worry of competition, at least for a specific period of time. This term is important, without the worry of competition, at least for a specific period of time. Say for the period of 10 years. After 10 years, what will happen and who will ask for competition? That cannot be imagine right now. So for a specific period of time, we can have intellectual property right. So what are the importance of IPR? Your IP rights can set your business apart from competitors, be sold or licensed, providing an important revenue stream, offer customers something new and different, form an essential part of your marketing or branding, be used as security for loans, and protect your creation against infringement by others. What is infringement? Infringement is nothing but one type of stealing. That is to stop others using, making, selling or importing it without your permission. So types of patents, if we consider, actually intellectual property right, there are different types of intellectual property right. If you have written a book, so you need to file a copyright. If you are going to publish a paper, you need to sign a copyright. So one thing is copyright. This is the copyright. This is the part of IPR. Second is patent. Particularly a new invention has to be documented by the government. So that is nothing but the patent. Geographical indication. Geographical indication, particularly, I mean, you have, you know what is Kolhapuri chappal. So Kolhapuri chappal, actually this is made from Kolhapuri, and this is Kolhapuri filed the patent. Kolhapuri state actually, or the region filed the patent for that Kolhapuri shoe. That type of shoe cannot be manufactured and sold by other companies. So Kolhapuri is one of the example of geographical indication. Trade secret. Trade secret means you are working, say, for an IT sector. There is obviously a trade secret. So for that, their companies are providing their personal laptop, and one IP is always observed, and whether this is making for other purpose or not. So this is the trade secret. Every company has trade secret and you have to maintain the trade secret. Trademark. Trademark means, say, this is there you find the McDonald's. So McDonald's, a big M is used. That is the trademark. That big M, exactly similar, cannot be used by other company. Hope you understand. There are, say, there are different that Coca-Cola. Coca-Cola, that italics type of letter that cannot be used by any other company. Okay, so this is the trademark of a company. Industrial design. Industrial design, in particularly manufacturing unit, when design a particular instrument or equipment or a machine, whatever, so they have, it has to be patented, because industrial design you will understand better for car manufacturers. Say there are Ford company, Mitsubishi, Suzuki, so they have their own design of car, and one design of car cannot be used by the other car manufacturing company. So the particular industry design has to be patented, and all the cars, new car that is coming on the market is first patented, then it is commercialized. So this is the example. I hope all of you can understand that is copyright, what is copyright, what is patent, what is geographical indication, what is trade secret, what is trademark, what is industrial design. Now, industrial design. One of the example of industrial design is shape, aesthetic features, configuration, surface pattern of an article cannot be copied by other company. And typical views are actually front views, rear view, left side view, right side view. So whatever, all the things are unique and cannot be copied by other company. That is the example of industrial design filing for IPR. Trademark, as already mentioned, there is Coca-Cola, there is Yahoo, there is YouTube, there is McDonald's, there is Samsung, there is Apple. That trademark is a distinctive sign or indicator used by an individual, business organization, or other legal entity to identify that the products or services to consumers with which trademark appears originate from a unique source, and to distinguish its products or services from those of other entities. Another one example is geographical location. As I have already mentioned, that geographical indication or GI is very common term in patent, right? So please keep remember this term. GI is a name or sign used on certain products which corresponds to a specific geographical location or origin. That I have already mentioned that this is for Kolhapuri shoe or Kolhapuri chappal, and this is particularly dedicated for Kolhapuri. This is Dehradun rice. This Dehradun rice has been patented first, then it has come to the market. So this rice is not available anywhere in the world. Next is Darjeeling tea. Darjeeling tea is premium quality. Darjeeling tea is highly unique, and it is first patented, then it has come to the market. Likewise, every unique product has to be patented, then it is commercialized. So geographical indication, hope all of you have understood. Then copyright. Copyright is nothing but, say your Windows, this is the copyright, this figure, this picture, this is dedicated for Microsoft Windows. They have made the copyright first, then launch their product in the market. So the exclusive and assignable legal right given to the originator for a fixed number of years to print, publish, perform, film, or record literary, artistic, or musical material. Not that it will change actually the given to the originator for a fixed number of years. That means actually the upgradation that is going on, that is first it was Windows 93, then Windows 98, then Windows XP was there, then we have got Windows 10, and likewise after a specific period of time, actually manufacturer launching their new version and making a patent for this new version by adding some additional features on the existing one and launching in the market. So they have to put the copyright first. They have to create the copyright first for their product. So patent is nothing but that type of invention which have novelty, which has inventive step, that is inventive methodology, and lastly utility. What is the utilization of the product? So this is an exclusive right granted by a government to an inventor to prevent others from making making a new product or any process. So say you have invented some idea, you have some idea, and you are going to fabricate the device. You need to first file a patent to register your idea to government, and then you should go for it. Otherwise, say you have an idea, say you need 1 or 2 years to launch your device. In between, if you don't file the patent, in between, say someone else will launch the product or use the idea and make the patent. So your idea or your new invention will be in vain. So when you have an unique idea, it should be patented first. What are innovation actually? So this is particularly pharma related, and any process for the medicinal, surgical, curative, prophylactic, or the treatment of human beings, and mere discovery, new property, or new use of a known substance, a substance obtained by mere admixture resulting only in the aggregation of the properties of the components thereof, or a process for producing such substance. So other are a method of agriculture, horticulture, method of playing games, topography of integrated circuit, a presentation of information, and this presentation can also be patented. So there are so many things that can be patented. And advantages of patent. What are the advantages? A patent gives you the right to stop others from copying, manufacturing, selling, or importing your invention without your permission, as already mentioned. And you get protection for a predetermined period, allowing you to keep competitors at bay. You can then use your invention yourself. Alternatively, you can license your patent for others to use it, or you can sell it. This right is with you. You can sell it, obviously, after getting some capital money in your hand. You can sell the patent or sell the idea, or you can sell this asset. This is actually the asset. This can provide an important source of revenue for your business. So indeed, some businesses exist solely to collect the royalties from a patent they have licensed, perhaps in combination registered design and trademark. So these are the references. If there is any question, feel free to ask me to this email ID or to my mobile number. Thank you very much.